Welcome, everybody. This is one of the two documents that were filed on the 13th of April, 2022. This is Michael Griesbach's brief to opposing defendants Netflix Incorporated motion to compel. Michael Griesbach, by his attorneys, Meyer Graf Wallace, provides the following opposition of defendant Netflix Incorporated's motion to compel. Background. Michael Griesbach, in February 2022, defendant Netflix served a subpoena pursuant to federal and civil statutes on Michael Griesbach for information related to a number of books that Mr. Griesbach authored about his impressions of the Netflix series Making a Murderer and the subjects discussed within the series. The subpoena, as Netflix pointed out in their brief, Mr. Griesbach is counsel of record for plaintiff Andrew L. Colborn. He is not a witness in this matter, nor should be forced to become one, as simply would not further this matter. As such, Mr. Griesbach objected to the subpoena. Docket 2072, objection. The parties then conferred, and Netflix remained insistent that Mr. Griesbach materials are somehow relevant to the outcome of the matter, despite Mr. Griesbach's explanation that all materials he reviewed are publicly available and his impressions of the same could not possibly qualify as evidence such that the jury could consider them. Netflix filed the subject motion to compel. Documents which Netflix seeks do not meet the standard of relevant evidence. They are nothing more than the thoughts, opinions, and conclusions based on a review of publicly available materials. I call bullshit. Michael Griesbach had a first-hand account on everything that took place before Stevens even released, after, and during the Holbach investigation. But Netflix wants the court to accept the idea that Mr. Griesbach's thoughts about evidence and evidence themselves and dispute that Mr. Griesbach's books are based entirely on his own impressions of publicly available records. Griesbach provides the evidence relevant, if any, tendency to make a fact more or less probable than it would be without the evidence, and the fact that consequence of determining the action. Under this standard, the evidence which Netflix seeks relevant in Mr. Griesbach's books were written based on his impressions and thoughts regarding publicly available information. This is the same information on which the defendants base their docuseries, and therefore do not have any tendency whatsoever to make any particular fact more or less probable. See generally Griesbach's affidavit provides, we're going to be reading the affidavit next, it's 52 pages, provides the relevant evidence and not admissible. Further, even if it is found to be relevant evidence, provides the exclusion of relevant evidence if the probative value is substantially outweighed by danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. There's a footnote. Ironically, the conclusions be reached are obviously explained in the books that were published. Accordingly, Netflix would seem to have another agenda. Specifically, one very obvious and unavoidable conclusion is that defense counsel is engaging in gamemanship aimed at making attorney Griesbach a witness, despite the fact that he is counsel. The evidence could not possibly be relevant to any fact at issue. The jury must and will be free to reach its own conclusion and impressions of the evidence. Thus, there would be nothing more than needless presentation of cumulative evidence, and it would be nothing other than prejudice Mr. Colborn by running his advocate into a witness. Advisory Committee notes the case law recognizes that certain circumstances call for exclusion of evidence which is unquestioned relevance. These circumstances entail risks which range all the way from including decision on a purely emotional basis at an extreme to nothing more harmful than merely wasting time, and at the other extreme. Situations in the area call for balancing the probative value and the need of evidence against the harm likely to result from its omission. The defendants are both wasting time with the endeavor and attempting to prejudice the plaintiff. There is simply nothing which would possibly make Mr. Griesbach's notes relevant to the matter. Mr. Griesbach, like many others, became fascinated by the case against Stephen Avery. It was a very significant matter in a small community in which Mr. Griesbach had worked in a criminal prosecution his entire career. His interest drove him to want to learn more about the matters, so he began to look through the public records of the cases, including court filings, the court-written decisions and orders, transcripts, and court proceeding, the transcripts of Netflix's own Making a Murder docuseries. Griesbach, like many that watched the series and or followed the news, particularly in Manitowoc, Mr. Griesbach formed opinions and was, to say the least, intrigued by Mr. Griesbach, then wrote his books based on publicly available information. Mr. Griesbach's books are, of course, publicly available and obviously express his thoughts and impressions. While Mr. Griesbach's interest may have given rise to books to the topic, the reality is that they're no different than the other persons who watch the Netflix series or follow the case in the news and form opinions, other than the fact that he close to the record and published his thoughts and conclusions. There's another footnote. Not only are there impressions of the evidence not evidence that it's only any jury could possibly consider, but a properly instructed jury, contrary to Netflix's apparent position, will be instructed to stay away from the books. Mr. Griesbach's notes are publicly available. Commentary on material extraneous to the case. Stated. If this is standard, then nobody who watched the series, read about the case in the news, wrote a tweet relating to the case, wrote a blog post about the cases, otherwise publicly expressed any opinion on the case, should be a witness in the matter. I'll be a witness. Other publicly expressed any opinion case should be a witness in the matter. They cannot be standards that simply defies logic and does nothing to further the matter. Indeed, the only logical conclusion from Netflix's position is that anyone familiar with any of these actual evidence would include jurors, judges, court staff, and on, are witnesses simply because they're familiar with the evidence. This cannot possibly be the law. The court recognizes a very real distinction between the evidence collected by law enforcement and the commentary, opinions, and reactions of the evidence. The defense counsel tried to blur the very real distinction, which, taken on logical and port, undermines, defies, and fundamental rules regularly employed by courts and those individual administration of justice. The immediate and practical impact of Netflix's position is that it turns plaintiff's counsel into a witness, thereby undermining the plaintiff's right to effective counsel. Netflix wants to turn Mr. Griesbach into a witness in this matter, and doing so, Netflix is undermining the plaintiff's right to effective counsel. Courts are generally quite concerned when persons attempt to play the dual role of counsel and witness, and for good reason. Wisconsin's advocate witness rule is set forth in Supreme Court Rule 23.7 and provides a lawyer shall not act as an advocate at a trial in which the lawyer is likely to be necessary witness unless the testimony relates to uncontested issue. Another footnote. Otherwise, the jury must confine itself to evidence admitted by the court. No court ever conceived of the possibility that notes, comments, opinions, and impressions created by someone commenting on the evidence could show in some way evidence itself. The testimony relates to the nature of the value of legal services rendered in the case. Disqualification of the lawyer would work substantially hardship of the client. The advocate's witness rule generally bars the lawyer from acting as both an advocate and a witness in the same proceeding, except under special circumstances. Well, I think this is special circumstances. Federal courts look to the relevant state court rules of professional conduct and understand the attorney as witness rule given the state. Trial courts have broad discretion in whether to allow attorneys to testify in a case in which he or she is advocate. There is, however, long-standing ethical prohibition against an attorney testifying for his or client in most cases. The rule recognizes the danger that an attorney might not be fully objective witness, as well as the risk that a jury could confuse the two roles when deciding how much weight to accord to testifying attorney's statements. As such, courts should not usually permit an attorney who is advocated in a trial to testify in a trial, especially where the value of testimony is small or collateral to the ultimate issue. The party seeking disqualification based on Rule 20.37 and the burden of providing necessary disqualification. List the case, State versus Gonzalez, Villarreal. Another footnote, while Netflix has not directly indicated that to seek the disqualification of Mr. Rierek as the plaintiff's counsel, it is certainly within the realm of possibility that Netflix's motives are more nefarious than simply collecting evidence. And even if Netflix is honest in its intentions, the ramifications of turning Mr. Greasebox into a witness cannot be taken lightly, as the risk of the plaintiff's right to effective representation is on the line. Courts have found the roles of attorney and witness usually are incompatible. The rule has deep roots in American law. Courts have noted that attorney is a drastic measure which courts should hesitate to impose except when absolutely necessary, because they are potential techniques of harassment. Motions for disqualification are viewed as extreme caution. While the defendants are not seeking disqualification outright, they are constructively turning Mr. Griesbach, an advocate for the plaintiff, into a witness in this matter. The Seventh Circuit Court has suggested that attorney's testimony is likely necessary within Frenzel he will testify. Still others have said that the attorney ought to testify if he has crucial information in his possession which must be divulged, or if the testimony is essential to the case. There is nothing which makes Mr. Griesbach's testimony crucial, essential, or foreseeable in the matter. I call bullshit. Mr. Griesbach considered publicly available evidence from the public sources and formulated his own conclusions and opinions, which happened to be available publicly in his book, just as every person who watched the Making a Murderer series did. Mr. Griesbach had no special powers allowing him to access the material. His only access came from reviewing public materials. Having scoured the content of Mr. Griesbach books, Netflix offers two brief excerpts as supposed proof that he relied on non-public sources and that he asked the court to speculate there must be more. The first expert is that the detail-oriented, Avery-obsessed Redditor friend of his investigated various phone calls Stephen Avery placed on the day Teresa Halbach was murdered. Contrary to what the defense counsel expresses, the expert supports a conclusion entirely at odds with which the position of Netflix, specifically Netflix, omitted from its brief, perhaps because including it would be believe its claim, which Mr. Griesbach actually wrote about Avery's calls. Having correctly cited the only page Mr. Griesbach provides as the subject, Netflix will know that the Avery-obsessed Redditor friend recounted nothing more about the subject than what was already in public domain, namely that the 14 calls Avery placed on the day he murdered Miss Halbach, he only used the *67 function on his phone. On the two occasions he called Miss Halbach, indefensible at page 178. The prosecution entered this and other evidence to show that Avery lured Miss Halbach to the salvage yard. Griesbach, effective exhibit trial and transcript. The irony of the Netflix admissions is not lost on anyone familiar with the facts of the case, because it admitted the same information in Making a Murderer. Netflix knows that the *67 evidence which is in the public domain, before Mr. Griesbach recounted in his book, became originated from one of the main sources of information that Netflix and the producer defendants used themselves in production in Making a Murderer. Not only did the producer defendants film the trial, but the transcript, along with thousands of pages of other court, Griesbach affidavit, Example B, StephenAvery.org web pages, Example C, transcripts, and then the next document's going, it's going to have all the exhibits listed and everything that's in it. The artists helped Mr. Griesbach review the gargantuan body of public documents. Hardly makes the information non-public, as Netflix claims. It is absurd that Netflix to assert that Mr. Griesbach used public documents to bring attention to essential evidence that Netflix and producer defendants left out of Making a Murder. Indeed, the assertion in Netflix seems to prove that admitted evidence purposely misinformed its viewers. The bottom line is that the contorted logic only undermines Netflix's position. The only other Netflix sites that prove that Griesbach relied on non-public information in his passing comments and indefensible that Mr. Colborn told a friend he hadn't watched Making a Murder, but he had heard about it. Document 206, page 7, citing indefensible. While admittedly non-public information, as Netflix notes, the court must determine whether the burden imposed recipient of the subpoena seeks the benefit of production of the material sought. Well, from my understanding, Andrew Colborn claims that he only watched, or didn't watch the documentary, but he only read the transcripts. And then he's the one that contacted Mr. Griesbach to take on his case. The fact that they're asking for stuff that he had before he even became counsel. But yeah, I'll read on. Given the breadth of the documents sought by Netflix and its limited, if any, relevance of the single statement of Mr. Colborn, the balance should weigh on Mr. Griesbach's favor, especially because neither Mr. Colborn nor his attorneys have ever suggested he watched Making a Murder before Griesbach wrote Indefensible, but the court need to not weigh the competing factors, because whatever benefit Netflix would have received from exploring the issue no longer exists, as Mr. Colborn conceded his most recent response to Integrity number 3 of Netflix's second set of interrogatories, and other few experts. He still has not watched Making a Murderer. Griesbach, Example E, Discovery Response. Having failed to find anything else in the book suggesting he possesses relevant, non-public information, Netflix unexpectedly cites that the fact that Mr. Griesbach emailed a link to a public radio interview to his home email address, as it did in his first citation in Mr. Griesbach's book. Netflix omits this content to the interview, undoubtedly because the interview impaired nothing that is already in the public domain. Okay, I'm going to stop here for a second. I hope Netflix attorneys has the email that Andrew Colborn sent to the new sheriff of Manitowoc right after Making a Murder came out. It's on my channel, you can look it up. Relevant non-public information and the basis demands that he turn over communications from his personal email account. There is nothing but a speculative attempt on the part of Netflix to create an impression that this is them speculating, saying that I hate the courts. This is absolutely without a foundation. Mr. Griesbach's affidavit verifies he had the same access to public records that anyone else did, or had. Netflix is attempting to create doubt in the absence of reason to believe doubt exists. The only credible and reliable conclusion that the record supports, based on Mr. Griesbach's affidavit and from information reported in the books, is that Mr. Griesbach relied on the same evidence available to anyone. It's in final attempt to convince the court that Mr. Griesbach notes and impressions somehow are in some way relevant to evidence. Anybody watching this, I don't know exactly when we got those 14 calls, the jail calls from Stephen and Jody, but I'd like to know, do we see those after he wrote his book or before? Because Not everything that's public domain now was public domain back then. Netflix seizes upon unsourced correspondence sent to news outlet requesting that it retract misinformation concerning alleged law enforcement misconduct in the Avery case. That fact, however, is that the correspondence was among the 30,000 documents Netflix received in response to a subpoena it issued to the Montauk County Sheriff's Department. The correspondence briefly references Mr. Griesbach's participation in drafting the initial search warrant for the Avery salvage yard. It also references the decision to have the Calumet County Sheriff's Department lead the investigation. Although it does not indicate whether Mr. Griesbach participated in that decision, on this basis alone, Netflix demands that Mr. Griesbach turn over any and all correspondence within the 15 individuals named in request number 11 under circumstances in which there are absolutely no basis to conclude or infer that Mr. Griesbach had a correspondence with the 15 individuals. This is another desperate effort by Netflix to drum up the issue where none exists. Once again, Netflix admits the public nature of the imparted information that it was in the public domain well before Griesbach published Indefensible. The Calumet County Sheriff's investigation reports, along with the myriad of other official documents in the Avery case, were released within weeks of Making Murder was released and months before Griesbach published Indefensible. The documents, which were promptly posted online, were released in response to the FOIA requests from viewers in Making a Murder, many of them who were wondered whether the documentary was true representation of the facts in the Avery case. Griesbach Affidavit F. FOIA request documents both Mr. Griesbach's assistance in drafting the search warrant and the decision that the Calumet County Sheriff's Department lead the investigation recounted in the reports, although there was no indication that Mr. Griesbach participated in that decision. Well, there's audio for that day that tells a different story, in my opinion, but my opinion don't mean nothing. Netflix has failed to show Mr. Griesbach possesses non-public information relevant to his defense. What Netflix has demonstrated is that it will twist words, logic, and desperate attempt to create an aurora of doubt and suspicion when the same simply do not exist. Having failed to show that Mr. Griesbach possesses non-public information relevant to his defense, Netflix turns to his public statements to justify its subpoena. As his first example, Netflix cites Mr. Griesbach's deposition testimony in Mr. Avery's wrongful conviction lawsuit, claiming it calls into question Mr. Colborn's recollection of events surrounding the phone call he received as a corrections officer in 1995 or 1996, including whether the caller identified Mr. Avery as wrongfully accused and Gregory Allen perpetrator. Well, side note, excuse me, I'm still getting over this cold. If there's no nothing nefarious going on, why did Andrew Colborn not wait until the day after Stephen Avery was released from prison to file a report with that exact information about the phone call he received? But predictably and without any basis whatsoever, Netflix overstates the extent of Mr. Griesbach's knowledge concerning the issues of which he explored. The review of Mr. Griesbach's testimony reveals he could offer nothing beyond his qualified recollection based on multiple levels of hearsay. One of Mr. Griesbach's colleagues, Assistant District Attorney Douglas Jones, had relied information he received from former Montauk County Sheriff's Investigator Eugene Couchet concerning Mr. Colborn's receipt of the call. Mr. Jones' memorization of their own conversation reveals that Mr. Couchet never told him his source for the information, making even Mr. Couchet's information unsourced. Using qualifying statements such as my recollection and impression is that what people were saying, Mr. Griesbach explicitly stated that he did not have personal knowledge concerning the information Netflix wishes to pursue. Not called bullshit. Again, given the remoteness of Mr. Griesbach's knowledge, Netflix has failed to show he is likely to have information that meets even the low bar of relevant application of discovery. Netflix can, in fact, has issued document subpoenas to persons who may have more direct knowledge of this information it seeks, at least when compared to Mr. Griesbach's recitation of the unsourced hearsay. Moreover, and as stated elsewhere in the brief, Rangley, the relevance of Mr. Griesbach's hearsay information concerning the 95-96 call must be weighed against other factors, including the burden placed by Mr. Griesbach's searching through documents dating back to nearly 20 years, as well as the exceptional circumstance that Mr. Griesbach would likely be forced to withdraw as Mr. Colborn's attorney if he were deemed to information relevant to Netflix's defense as such tenuous grounds. In yet another attempt, Netflix turns to Mr. Griesbach's books, citing first his reference to the innocent killer to a document left in the former sheriff's safe. According to Netflix, Mr. Griesbach states unequivocally his book that Colborn's 2003 report regarding the telephone call, which is hidden in the sheriff's safe, not delivered promptly to the Attorney General, or Mr. Colborn contends that this action. Netflix has confused one of his hopes inadvertently. Which document Mr. Griesbach was referring to? Although Netflix admits it is clear from the context that Mr. Griesbach is referencing an affidavit from a jailhouse snitch kept by the former sheriff in his office safe, not Mr. Colborn's 2003 report. Okay, well, I don't believe that either. Because, yeah, I'm just going to continue reading. Contrary to Netflix claims, Mr. Griesbach has never suggested, whether in his books or anywhere else, that Mr. Colborn's 2003 report was not properly turned over to the Attorney General. A fact that was documented by the agency tasked by the Attorney General to gather information in the Wisconsin Division of Criminal. And this is why Pagel is so concerned after Stephen Avery takes out his lawsuit against the Manitowoc Sheriff's Department, Dennis Vogel, and Tom Kaczurek, because it's going to all point towards her in the end. Because the state of Wisconsin did their own investigation after Stephen Avery was released from prison, and Amy Liam and Deb Strauss and Pagel all together deemed that it was the victim's fault for identifying the wrong person, and there was no wrongdoing by the state or its officials, which is a bullshit fucking lie. Netflix argues that additional passages from Mr. Griesbach's books prove he has information relevant to his defense. These rings seemingly hollow. There is nothing novel. For instance, Mr. Griesbach's telling Mr. Colborn's colleague, James Link, that when defending a client at trial, criminal defense lawyers are permitted to falsely accuse police officers of wrongdoing because a person charged with a crime has a constitutional right to defend himself, and the media has a right to cover the story completely. As conceded by Netflix, Mr. Griesbach was responding to Mr. Link's displeasure about his reputation being sullied by Mr. Avery's lawyers at trial, not by a documentary released 10 years later than the distorted facts beyond what Mr. Avery's defense team presented. Moreover, there are a myriad number of methods or ways Netflix can explore whether the trial itself and not making a murder ruin Mr. Colborn's reputation without destroying Mr. Colborn's right to retain counsel of his choice. Netflix references the excerpt from which indicates that Mr. Colborn wished to spend Christmas days with his family, who still loved him, and this was dashed because of the viewer reaction to Making a Murderer. Netflix's argument that the passage obviously undermines Mr. Colborn's claim that Making a Murderer destroyed his marriage rationally assumes that Mr. Colborn's marriage was destroyed all at once just 2 weeks after Making a Murderer aired. Again, regular, and any benefit Netflix might receive to exploring the issue with Mr. Griesbach vastly outweighed by other factors, including Netflix and exploring the issue of actually examining the records for Mr. Colborn's divorce. The remaining excerpts cited Netflix expressed nothing more than Griesbach's opinions of certain aspects of the investigation. many of which show his opinion evolved from time he watched Making a Murder to a later period following the review of the evidence. At the point, he learned how badly the defendants has misled viewers. Netflix offers no explanation on how Mr. Griesbach's opinions are relevant, especially those formed when he knew little other than Netflix spoon-fed its viewers. Regardless, Mr. Griesbach's opinions are no more valued to Netflix than other hundreds of thousands of other similarly obsessed observers of the Avery case and Making a Murder. Now, you can see an email that Michael Griesbach sent to Netflix and his producers after it aired, commending them on how good of a job they did. Now he downplays the situation, said he would have been able to enjoy it a lot more if he wasn't personally involved with this bullshit. The same can be said when regard Netflix citation and congratulatory email by Griesbach sent to the producer defendants on December 23, 2015, approximately 1 week after Making a Murder release. Having liberally cited indefensible, Netflix understands that Mr. Griesbach's opinion changed drastically upon examining the facts. Indeed, the defendant's manipulation of the truth is an indefensible central theme. In fact, the radio interview Netflix cited in its brief was a conversation about the significant degree of which Making a Murder distorted the truth. In short, Mr. Griesbach's opinion is not only irrelevant to Netflix's defense, in fact, it supports Mr. Colborn's claim. Cough drop. Mr. Griesbach's research and protected under Wisconsin statute, which is an absolute privilege which Netflix did not mention nor address. Wisconsin statute provides relevant part, no person having the power to issue a subpoena may issue a subpoena compelling a new person to testify or produce or disclose any of the following that is obtained, prepared by the news person and the news person competitive in a gathering, receiving or preparing news information, potentially dissemination of the public, any news or information obtained or prepared in confidence by the news person, and any news information or identity of the source and news information. A news person is defined as any person who is or has been engaged in gathering, receiving, preparing, disseminating news information to the public for entirely described in par. So I guess I'm a news person, y'all. Including in business organizations. That means by print, especially regular, consistent, basic news information to the public, including book publisher. Mr. Griesbach falls neatly under the definition of news person. Mr. Griesbach gathered information to the public. This is so stupid. Published the Pinnacle Books. Pinnacle Books disseminates information to the public by publishing books on a regular basis. The statute clearly prohibits Netflix from obtaining any news or information obtained or prepared in confidence by the news person, as well as any news information or identify any source, any news or information. There's a broad categories in which cover the information gathered by Mr. Griesbach and his preparation of his books. While Mr. Griesbach has already indicated that he relied exclusively on publicly available information, the reality is Wisconsin statute absolutely protects him from disclosing specific documents, persons, and other information which he utilized for his books. But if it's public, why shouldn't he be able to release it or prove that it's not public? The statute by itself must dictate the outcome of Netflix efforts. Despite this, at no point and no place, Netflix has noted the existence of fundamental evidentiary prohibition. The legislature clearly felt that the need to provide strong protection for those wishing no disseminated information to educate the public. Even if a party gets a hold of such information, they are prohibited from utilizing it. As the statute states, any news, information, records, communications, or identity of source of any news or information obtained in violation of the section inadmissible for any purpose in judicial, legislative, or administrative actions, proceeding, or hearing. Thus, Netflix neither entitled the information nor could it use the information in the matter even if it obtained it. Further, a disclosure, no another person, dissemination of the public reviews information and identity of the source by a news person does not constitute a waiver of the protection of the compelled disclosure. Yada, 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 yada. As such, even though Mr. Greasebach's book is published, and even though he has already indicated that he relied on publicly available documents, he did not waive his protection from compelled disclosure. It is likely that the legislator was attempting to protect such authors such as Mr. Greasebach from citations exactly such as this, and any author can suddenly become a witness because of their interest in the research into a topic. Their incentive to provide information and thoughts to the public is greatly diminished. Such legislation and protections necessary to protect harassment of those disseminating information, thereby ensuring the news and information can be disseminated in the public. Some of the most fundamental concepts underlying our society are the rights to free speech and freedom of press. Without such protection, speech and press are likely to be inhibited by fear of retaliation and concerns of being dragged into litigation for any number of reasons. Mr. Greasebach clearly fits within the parameters of the legislation and therefore granted its protections. Netflix and its counsel have taken a position that has no basis in evidentiary law and the law of discovery. It is a position that is absolutely prohibited by Wisconsin law. This, of course, leads to the question, of course, of why Netflix would do this. Counsel for Mr. Greasebach suggests that Netflix has a motive that exceeds the scope of its effort. It may be to harass, it may be to disqualify counsel chosen by Mr. Colborn. Now, how is it that they can speculate what Netflix is doing, but it's gay? This shit's so stupid. We all never know, but we do know what the information material sought by Mr. Greasebach is anything but discoverable. Relevant evidence, the legislator unequivocally barred Netflix from obtaining such information. There are many other common sense reasons based on the fundamental rules of evidence and discovery that not only regard Netflix efforts, but strongly condemn the same. Dated the 13th of April, 2022. Well, yeah, that was fun. There's a 52-page document, which I'm probably going to read tomorrow because it's getting pretty late. So, all the other documents has all the exhibits and all the bullshit he cited in this bullshit-ass response. But, yeah. See y'all next time, and stay blessed.